Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We have 6 arguments on today's calendar. Judge Rovner is part of the panel and has prepared for argument, but unfortunately is not able to join us. She will listen to the recordings of the arguments, participate in the panel's deliberations and resolution of each of the appeals, though. We'll begin with appeal number 2448, Amy Hadley versus the City of South Bend. Ms. Miller, good morning.
Good morning, and may it please the court. Marie Miller for the appellant, Amy Hadley. So the first question here is whether Johnson controls, and it does not, because the rule of decision in Johnson was a broad, categorical, exclusionary rule for the takings clause that is incompatible with more recent Supreme Court decisions. And the year after Johnson was decided, the Supreme Court in Arkansas Game and Fish instructed that takings claims must be assessed, quote, not by resorting to blanket exclusionary rules, end quote, but by referencing the particular circumstances of each case. And since then, the Supreme Court 2 more times has vacated blanket exclusionary rules for the takings clause, and 8 of the court's 9 takings cases have involved exercises of the police power outside of eminent domain condemnation proceedings. So Johnson's categorical rule can't survive these precedential developments, and the courts in this circuit must start afresh in applying traditional takings rules to the particular circumstances of each case. And this court already did that in Conyers. There, the government argued for Johnson's rule. The district court quoted Johnson's rule and relied on it. A panel of this court rejected that rule, and the court declined rehearing en banc. Now, as Conyers demonstrates, rejecting the government's rule does not mean that the court will find a compensable taking, but the court must use the proper mode of analysis, and the district court here did not, because it felt constrained to adhere to Johnson's categorical rule. At least
Ms.
as a starting
Miller, you wrote a very good brief, and you're summarizing it, which is helpful. Can I ask you a question, though, about kind of what's embedded in what you're saying?
Of course.
If you had to capture in 1 or 2 sentences the rule that you would like us to announce, what would those 1 or 2 sentences be?
When, as here, officers on the government's authority intentionally destroy an innocent person's property while trying to apprehend a fugitive, that set of facts invokes the per se takings rule, and that is because the government's action has ousted the property owner of her rights to possess, use, and dispose of the property the government destroyed. Then the government can avoid the compensation requirement by establishing entitlement to a historically grounded exception. Here, the government has not done so.
Okay, and would there be a carve out in a no-knock stash house warrant situation?
No, there would not be a carve-out for that. Now, the government points to a common law privilege to forcibly enter a home to execute a warrant, and the argument is that because Ms. Hadley had no right to exclude the officers from her property to execute the warrant, she had no other property rights that they could have deprived her of.
Right. Think outside of this case, though, for example, about a no-knock search warrant issued on a stash house. And a team shows up at 6 o'clock in the morning, as we see in many, many cases here, and the front door. The search begins with the front door being knocked down. Takings claim as to complete destruction of the front door, 100%.
Well, I'd want to know a few more things. First, was the officer refused entry to the front door?
They never asked because they were it was a stash house, and they were authorized to knock the door down. So no knock warrant.
There may not be a taking for the door itself, but if the officers
and why not?
Well, because if the owner of the house was part of this stash inside, then the owner is culpable. They're not an innocent owner. And innocence does matter for takings analysis. It goes back to the whole animating purpose of the Fifth Amendment. The whole point is to level out an imbalance of benefits and burdens favoring the public as against the individual property owner. If the property owner imposes a burden on society by having
We don't, so innocence in what sense?
Innoc-
Ultimate innocence?
Innocence in imposing a burden on society. So if the owner has imposed a burden on society, then the government can offset that burden without invoking the takings clause, without triggering the compensation requirement.
So let me give you a different fact pattern. Suppose, for example, we have a child sex offense investigation that results in a search warrant authorizing computers and iPads and what have you. We see that all the time. And in the course of the execution of that search warrant, there's all kinds of damage to the property. Kitchen tables broken, closet doors are smashed in, et cetera, that way. How does this innocence factor fit into that kind of analysis?
Well, if the owner of the property is the person that is the sex offender, then that person has already imposed that burden on society, and the damage is simply offsetting that burden.
So you're asking us, so you're saying in this particular case, Ms. Hadley is truly, in every sense of the word, this is the wrong house.
Precisely.
Okay, but no takings claim in the situation where all they were after is laptop computers, and you have the closet and the kitchen table and the cabinets are pulled off the wall, and bedroom furniture is destroyed.
Oh no, there could be if they go well beyond what they needed to do and what
For
they were
takings,
authorized.
on takings grounds?
Yes, if they weren't authorized to do what they did, if they went well beyond what they were authorized to do, then there's no taking. There must be authorized action.
Okay.
Would your test draw a distinction between when action is necessary and when it's inevitable?
When an action is necessary versus
So-
inevitable?
If it's necessary to execute the warrant, take the no-knock warrant. It's necessary to breach the door. It might be necessary to do additional damage to the house, but not necessarily inevitable, right? You can imagine a number of reasonable ways to execute the warrant after the door is breached. Where do you draw the line there in terms of when compensation is due?
Well, I'm not sure that necessity is going to dictate the answer here. If the property was destroyed pursuant to a public purpose, then the takings clause is invoked. There could be exceptions that still apply when the damage was necessary. Now, if the damage was inevitable, I don't think there's going to be a taking there. That goes, the first rationale in YMCA teaches that. If there's inevitable destruction, and I believe Caltex also uses this reasoning. If the damage was inevitable, then it wasn't by the government. There's a causation is absent in that situation. But my friends point to the common law privilege to forcibly enter to execute the warrant, and they say that because Ms. Hadley had no right to exclude, she also had no property rights they could have taken away. But here, the government's action exceeded the common law privilege in 3 separate ways. First, the privilege was limited to door breaking, which is a term of art that has the same meaning as used in the crime of breaking and entering. And here, the officers didn't bust through the door to get inside or break the windows to climb through. They were inflicting damage to get someone to come out. Second, the privilege was limited by the knock and announce rule. Peace officers had to be effectively refused entry. Ms. Hadley and her son, who was home at the time, did not refuse the officer's entry. And third, the privilege to forcibly enter a third party's home to make an arrest was limited to situations where the arrestee was pursued to that house. And the arrestee here was not pursued to Ms. Hadley's house.
What's the relationship, in your view, if any, between a Fourth Amendment analysis of the reasonableness of the search and a Fifth Amendment takings analysis? Is there any relationship between the two under the test you proposed?
There is a relationship only for situations involving a deprivation of the right to exclude by itself. And that comes from Cedar Point. In Cedar Point concerned only a right to exclude all by itself.
But Cedar Point also has that language, and I'm looking right at it. The government searches that are consistent with the Fourth Amendment and state law cannot be said to take any property right from landowners.
Exactly, and that's why the reasonableness of a search matters only for those situations, or does matter for situations where the right to exclude by itself has been implicated.
Okay, so is there a fact pattern that exists in your mind where you would say there is no Fourth Amendment violation here in any way, shape, or form with respect to anything that happened during the course of the search, but there is a Fifth Amendment takings claim?
Oh, that's what we have here, yes. So usually, if a property right other than simply the right to exclude has been deprived, then the Fourth Amendment is not going to insulate that activity. And the Fourth Amendment's work in the right to exclude context is simply establishing whether the right exists in the first place. You don't have a right to exclude an officer lawfully executing a warrant, but that says nothing about your rights to possess, use, and dispose of the property. The entire issue in Cedar
Yeah, I mean,
Point.
that seems odd to me then, if we go back to our stash house example, that the police are authorized in executing the search of the stash house to knock down the front door, and the front door is 100% destroyed, as I expect is probably the case in a lot of these searches. That you might have a takings claim there where there's absolutely no Fourth Amendment violation. Indeed, it's authorized.
I'm not sure that the door breaking is going to be covered because of the common law privilege to break the door. But apart from the door breaking, other damage isn't covered by the common law privilege, and the Fourth Amendment can't insulate it outside of the context of a situation.
So they're searching for kilos of heroin. They get to the bedroom and the closet's locked. They're knocking the closet door down, I can guarantee you.
Oh, that's part of the common law door breaking privilege. You can break multiple doors to get inside where you need to get into. It's not just the outer door of a building. It's inner doors as well.
So can you go back? So with all of these kind of qualifications in mind, what test do you propose?
Well, it's what I mentioned
I mean,
earlier.
there's a lot of exceptions that
there
you're
are.
recognizing in what you're saying.
There are many exceptions, and that goes to show that our view is very measured and tied to the specific facts of the case. The Supreme Court has instructed that these takings cases are very fact-specific. By contrast, the government's position is that law enforcement activity can never give rise to a taking. They're dealing in absolutes here. In our view,
We have some questions for them too, don't worry.
but there are exceptions. So destructive law enforcement activity might be outside of the takings clause because the destructive act wasn't intentional, the destructive act wasn't authorized, because the destruction was inevitable, or because the owner was culpable. These are all exceptions that could apply. They don't apply here, though. These may be exceptional circumstances, and we're here again on a 12b6. We have no factual development.
So how does your test apply to the stash house? We'll stick with the stash house example. But say you tear down all the walls. Say there's a wiretap saying, yep, this is a stash house. They see drugs coming in, coming out. They have a source saying that there's drugs in there. But, sometimes people get smart and remove drugs. So all the drugs are gone. They tear down all the walls. They find a bunch of hidden compartments. No contraband is found.
Yeah, I don't think whether the contraband is found is going to play a part in the analysis, but I do think what matters is whether the owner of the house was part of this stash. Now, the government could far exceed, what they
And so do you
should have-
litigate that? Does it come after a criminal case is completed? How do you resolve that case with your test?
Oh, well, the owner will have to establish that they own the property, and then if a person is not innocent, that's something that the government can point to. I see I'm in my rebuttal time and would like to reserve, but thank you.
Okay, very well. Mr. Smith, good morning.
May it please the court. Joseph Smith for the City of South Bend, but I'm speaking for all the FLEs today. Damage caused by law enforcement in the course of their law enforcement duties has never been considered a taking under the Fifth Amendment. Plaintiff cannot cite a single case except a reverse district court decision that has ever held that damage caused by police officers in the course of their law enforcement duties is a taking that must be compensated for. And all of the case law that has addressed this question, other than the one reverse district court case, has been to the contrary. Blake, Slaybaugh, Amerisource, Buchanan v. U.S., Johnson v. Manitowoc County, Lawmaster v. Ward, Leck v. Johnson, McKenna v. Portman, Zitter v. Petrocelli. All of those cases addressed this issue, and all of them found there was no taking of the Fifth Amendment.
Let me ask you a hypothetical, because the case as presented to us is asking us to reconsider this kind of, much more broadly. Yes, in the context of this fact pattern. So let's suppose, for example, that here, I don't remember this guy's name, Johnson something. They were looking for a fugitive, right? That the use of the tear gas canisters that were shot through the window, and the use of these hand grenades, unexpectedly started a fire, and Miss Hadley's home burnt to the ground entirely. Now, everybody admits this is the wrong house, right? And Miss Hadley is now out a home. What then?
That would be an issue for state tort law. If the police negligently started a fire that burned the house down, that would be an issue for state tort law, not a takings issue. I think even under plaintiff's test, it was not intended that they would burn the house down. There may be an argument about whether it was foreseeable, but police departments use these
Any
kind of
Fourth
things all the time.
Amendment 1983 claim for money damages? Set aside qualified immunity.
That would be an issue, yes. If the plaintiff who owns the house can always claim that the police acted unreasonable, that it was unreasonable for the police to use these tear gas grenades, flashbangs to break down the door, that option is always available. And we've had that framework for determining whether law enforcement action is lawful since the Constitution and the Bill of Rights were ratified.
So if we have an authorized search of a home for income tax records in a tax fraud case, and the search happens and the home is almost destroyed,
That would be a
1983 action for money damages?
that would be a Fourth Amendment reasonableness issue, not a Fifth Amendment takings issue, and possibly a state tort law issue. But it would not be a taking because of the nature of the action was a search. And the Supreme Court tells us we have to look at the nature of the action. Whether property was destroyed as a result of that action may be relevant to damages if the action was unreasonable under the Fourth Amendment.
So your position is that, as I understand it, that we can't hypothesize any set of facts. So if we sent this question over to the law schools in town and said, sit around all day long and make up fact patterns, you can't come up with one where a search results in a taking. It's literally an empty set. It doesn't matter how deliberate, how egregious, how extreme, nothing could be hypothesized.
Because we look at it under the Fourth Amendment, not the Fifth Amendment. The nature of the action is a search. The amount of the damage doesn't matter for whether or not it was a taking. It matters for whether the search was reasonable. But a search doesn't become a taking because it does a lot of damage. It's just not a taking. That's all the cases have said. Look at Zitter v. Petrocelli, where the plaintiff had hundreds of thousands of oysters that were grown in violation of state regulations. They were all seized and destroyed. 100% loss of his stock. That was not a taking. It was a law enforcement action.
What's the best Supreme Court precedent you can think of that rules this out categorically?
I'm not asking for a categorical rule. I want to be clear about that. Because even if it's a police power action, the precedent has been clear that a police power action can also be a taking. So,
Okay, if it's not categorical, give me the hypothetical that fits within the category that's allowed.
I can give an example for law enforcement. Let's say the police came to Ms. Hadley's neighbor's house and said, there's a fugitive on the loose. We'd like to set up an office in your basement to look for him. They do that without their permission. They basically set up an office in the neighbor's basement. That would be a taking because that would be using the neighbor's home as though it was an office for the police department. So that would be a police power action that would be considered a taking. Even though they're looking for a fugitive, they are using the neighbor's property as though it belonged to the government. I can give another example. If the police department was using the neighbor's field as extra parking because they didn't have enough parking, that would be a taking if they were doing it without the owner's permission. If the government needs more parking for the police department, it should condemn the neighbor's field and turn it into a parking lot, not just use it.
But to me, those are examples of the police department not exercising police power. I think you are advocating for a categorical approach to say, if the police department is out there exercising its police powers, search, arrest, none of that's a taking. Is that correct?
With the example of using the neighbor's basement, I think that would be police power. That would be considered a search. I don't think there's any question about that.
With or without consent?
Well, as I said, if the neighbor did not allow it, they took the basement for the use of an office to search for a fugitive.
I mean, you'd hope the neighbor would say, "Where's the warrant?"
Just hypothetical.
All right.
So we're not asking the court to say that everything that the police do is out of bounds with the Fifth Amendment. You have to do what the Supreme Court says and look at the nature of what the police are doing. And if the nature of what they're doing is a taking, then then you have Fifth Amendment liability.
In what case do you have that would say that? I mean, we have Baker, where that's not binding. It's two justices highlighting an issue, but there's nothing in that to suggest to me that there's this bright line. It's pointing out an issue percolating in the circuits.
The Supreme Court has been very consistent that there is a distinction under the Takings Clause between eminent domain and police power. And when I say police power, I'm not using it in its broadest sense as anything the government might lawfully do. Police power has been used in the context of the Takings Clause to mean something that is not eminent domain. It's long been recognized that if a police power action steps over that line into eminent domain territory, then it is considered eminent domain and it is a compensable taking. But you go back to
So the examples you give about neighbors and fields and basements and all that stuff, those are examples where you've taken the focus away from the searched premises, right? Just by definition.
yes.
And what you're saying is, though, it does seem to me, unless I'm mishearing you, that your view is that as to a searched premises, it's categorical. So now bad facts can make bad law. We all know that. But if you had a fact pattern that said that child sex offender, when you're going after the laptops on this search warrant this afternoon, destroy that house. Don't make sure that tear it apart, do whatever you have to do. Just make sure that house is destroyed after that search warrant.
That would be a Fourth Amendment issue, not a Fifth Amendment issue, and possibly also state tort law. The search does not become a search just because it does a taking just because it does a lot of damage. And one of the issues that I have with plaintiff's proposed test is that it divorces the search itself from the results of the search, meaning the damage. If the damage from a search is a taking, how can we say that the search itself is not a taking? So I think that would have to result in...
So suppose we disagree with you. You heard what Ms. Miller offered as her test. Just for purposes of the question, assume we disagree. How would you formulate the test?
I would simply reaffirm Johnson v. Manitowoc County, possibly make clear that Johnson did not use the police power in its broadest sense, but in the context of the Takings Clause, meaning that if it's not an action that results in a taking, then it's not compensable. That's what the Supreme Court said in Venice. That's what the Supreme Court said in Mugler.
You're just saying just edit it, but make clear it's categorical as to takings liability.
Well, again, I disagree that we're talking about a categorical rule. We still have to look at the nature of the action. And in most
But all we're
cases,
talking about is the execution of search warrants, aren't we?
we are talking about the execution of search warrants, yes. So if the court wanted to limit its holding, it could limit it in that way. That damage incidental to a search is not a taking. You have to look at it
Full
at the
stop,
Fourth Amendment.
no matter what, categorical, doesn't matter how bad the fact pattern is.
It's a Fourth Amendment issue, not a Fifth Amendment issue. If the police acted unreasonably, then the property owner has a Fourth Amendment recovery. I think our proposed rule has some benefits that plaintiff's proposed rule does not. Under our proposed rule, a homeowner who's not innocent does not still has the right to recover in the event of unreasonable police action. Our rule allows police officers to know before they do what they're trying to do whether or not they're going to violate the Constitution.
But let's focus on Johnson for a second, because my first step is, does Johnson control? Johnson said that the takings clause doesn't apply when property is damaged as a result of the government's exercise of police power, but it based that on Venice, which was a car forfeiture case, right? So you have it kind of underpinning in forfeiture, and then as counsel said, we decided Conyers, that was confiscated property. How far does the rule in Johnson go, and does it control here?
Johnson controls here just because other decisions of the Supreme Court have addressed police power actions that were actually takings doesn't mean that all police power actions are takings. And I disagree somewhat with plaintiffs' description of the later Supreme Court cases as police power cases. Those were eminent domain cases. Cedar Point Nursery v. Hasid, plaintiff describes that as a police powers case. That was taking of an interest. That's what the Supreme interest in easement. That's what the Supreme Court said. Horn v. Department of Agriculture, plaintiff describes that as a police powers case. That was a classic taking of the raising growers' produce. And then going back, U.S. v. Cosby, plaintiff describes that as a police powers case as well. That was also taking an easement from a property owner. So calling a case a police powers case doesn't make it so. You have to look at what the court was actually looking at in those cases. And those were classic takings, or the same thing as a classic taking.
I mean, one thing you got going for you, Mr. Smith, is no circuit court in the United States that I can tell has ever held that anything in connection with the execution of a search warrant is a taking, not in an unqualified way.
Agreed, yes. And again, I don't know how we can separate the search itself from damage caused by the search. The damage is the damage from the search. So if the damage is a taking, then wouldn't the search itself have to be a taking as well? It's as much of an interference with the property owner's interest as the damage, sometimes more so.
Yeah, I mean, the hard question the justices are going to have to resolve it one day is the relationship between the amendments. That way, the Fourth Amendment analysis, I don't think is all that difficult. Where we see searches all the time that exceed a standard of reasonableness, and then oftentimes we'll see a 1983 claim on the heels of it. That's not uncommon.
Right.
The law is pretty comfortable with it.
And as we've said in the brief, I think there's a strong distinction between the Fifth Amendment takings clause and the Fourth Amendment. The Fifth Amendment talks about takings. The Fourth Amendment talks about searches and seizures. So we should look at it from the viewpoint of searches and seizures.
Okay. Anything else?
Yes, I would like to address plaintiff's suggestion that there's no historical analogs.
Well,
I'm
we're
out of time.
kind of
All right.
It's in your brief, right?
Well, no.
Why
I was
don't you
just going to bring up
give us 20 seconds on
all
it?
right. I was going to bring up the statute 1275, which is in the brief as a historical analog, as well as the apprehension of John Wilkes Booth, where the barn that he was hiding in was burned to the ground in order to flush him out, which was successful, although he was shot in the process. So the type of damage alleged in the complaint has always been possible. Thank you. We ask that you affirm.
Okay, Mr. Smith, thanks to you. Ms. Miller.
Thank you. I'd like to offer a path forward that I don't think we've addressed yet. Because the district court below relied on Johnson's categorical rule, at least as the starting point, this court doesn't actually need to decide whether applying traditional takings principles to these allegations does or doesn't result in a taking. It's enough and appropriate to simply vacate the judgment below and remand because Johnson supplied an improper analytical framework, and allow the district court another go in applying the takings principles in the first instance. And that has the advantage of heeding the call by Justices Sotomayor and Justice Gorsuch recently in their statement concerning Baker, that the lower courts should take a close and careful look at this issue before the Supreme Court takes it up to resolve the circuit split. And if you're concerned about orderliness, then I suggest circulating the opinion under Rule 40E. I don't believe that's required here because the circuits are already split and the Conyers panel didn't circulate that opinion even while rejecting Johnson's rule, but we are not opposed to circulation here. This is a prime candidate for the court to clean up its case law that's out of sync with modern Supreme Court precedent. Johnson supplied no analysis whatsoever in adopting the police powers rule. This court hasn't relied on it even once. It was rejected in Baker, in Conyers, and it's been rejected and criticized in Baker and Slaybaugh as inconsistent with tradition, history, and precedent. So if you do not agree with us here that compensation is required, then we ask that you at least vacate the judgment and remand for the district court to reevaluate the complaint unencumbered by Johnson. Thank you.
Okay, very well. Ms. Miller, thanks to you and your colleagues, and Mr. Smith, thanks to you and your colleague. We'll take the appeal under advisement. Our second argument of the day is in Appeal 24-1903, the United States versus LaPierre Scott. Okay, yep, Mr. Greenberg, nice to see you whenever you're ready.
Morning. I have to say that this is a factual situation that I never thought when I went to law school that I was ever going to encounter, whether you would have to lock a bathroom door. And when I was thinking about this argument and I was talking to my wife about it yesterday, I was thinking of the opening scene from the movie Planes, Trains, and Automobiles, where Steve Martin and John Candy are running for the cab. And I was thinking of it as if you're running for the bathroom door somewhere and the two people are running. And if two people ran for the same bathroom and it was a single user bathroom and someone beat the other person to the bathroom, the person who didn't make it to the bathroom wouldn't then burst in just because they didn't hear the door lock. And that's really what we have here. We have a ruling by the trial court that just because somebody didn't lock the bathroom door, society does not recognize a privacy interest in the bathroom.
But here, the bathroom's also out of order. So we have a privacy interest. Courts have talked about privacy interests in various places. But is this even really about a single stall bathroom, or is this about just any other room in a gas station because the bathroom's out of order?
Well, the bathroom may have had an out of order sign on it. We don't know what was wrong with the bathroom, and the trial court didn't really place much emphasis on the fact it was out of order, except it said someone else could have come in at any time to fix the bathroom. But that's not really important here, because the person who's using the bathroom, and I hate to get graphic here, although we sort of did in our brief, They don't care if the bathroom's out of order, frankly. If you've got to go, you've got to go, right? And you don't care what you're leaving behind for the person afterwards. So if you've got to go to the bathroom, you're either going to go to the out of order bathroom, or you're not going to go in the aisle. You're not going to pull up behind the gas station and risk getting arrested for public indecency. You're going to go in the only place you can go. And you don't care if you can't flush the toilet. And if the toilet's not working, maybe you're going to go, frankly, in the sink. That really doesn't matter. It's a bathroom. And you have to assume that somebody goes in a bathroom to use a bathroom as a bathroom is intended. Whether they can flush the toilet or not, whether they can wash their hands, doesn't matter. It doesn't give a police officer, they're not a hygienist. It's
Mr.
not
Greenberg,
up to
would
them to check the toilet paper roll or something like that.
Take, just change the fact pattern in one small way. Take that sign and change it. And have the sign say, closed, do not enter. Same analysis.
Yes, it's the same analysis because it's none of the police officer's business. The stipulation at the hearing was that they had no reasonable suspicion, they had no probable cause. So why are they going in there? They had no reason to go in there. They weren't going in there because they suspected a trespass. So they had no reason to go in there. And when the trial court said, well, a plumber could have gone in there, someone from the gas station could have gone in there, sure, someone from FedEx can open a package that a police officer can't open. Someone from the Geek Squad can look on a computer that a police officer needs a warrant to look at. But a police officer is different. They are a government actor.
So it sounds like I think this is in your brief, or it's between the lines anyway. Your point is, okay, fine. They want to talk to Mr. Scott about the robbery. Wait outside, stand outside the bathroom door. I mean, where do you think he's going?
Right. And they didn't even say they wanted to talk to him about the robbery.
Well, this business, whatever this thing's called, field interview or something. I mean, they want, whatever that means, they wanted to talk to him about something.
They wanted to talk to him, but they never said why they wanted to talk to him. This record's silent as to why they wanted to talk to him. The fact is that they saw him go in there, and for some reason, they followed him. There's really no reason in this record.
I thought they were, maybe I'm wrong, we'll see what the government says. I thought they were making a call on the place because it got stuck up earlier in the day.
So in the morning, there's a robbery at the gas station. And at the hearing, which was a stipulated hearing, it was during COVID. So we stipulated to the facts. We stipulated that the police didn't have probable cause or reasonable suspicion, that they saw him walk into the bathroom, that the door was closed, that they had no reason to suspect he was doing anything illegal, and that there was the out of order sign.
Yeah, fair enough. But they weren't just swinging by the what was it, a Golf Quick Mart or something to get a cup of coffee, right? Weren't they? They were in a radio car, and weren't they aware there was a robbery there earlier?
They were going to get video. They were going to collect the video from earlier in the day. When we had the trial in the case, one of the officers said that when he looked at Mr. Scott, he thought he fit the description of the robber from earlier, and the government put that in their brief. But if you look at the cross-examination, he really didn't. The only similarity was that he had on a multicolored jacket. The rest of his clothing didn't fit the description. His complexion didn't fit. His facial hair didn't fit. In fact, the description from earlier wasn't even whether it was a male or female. And eventually, the witness conceded that he didn't have any reason to believe he was involved in the earlier robbery. So there's really no reason in this record why they wanted to talk to him. They just saw somebody who, when they approached, walked away from them, which is not an uncommon occurrence. And if you watch the video, he doesn't even walk away in a fast manner or anything like that. There's nothing really suspicious about the way he walks away from them. The touchstone of the Fourth Amendment in all of these cases, and I know that the trial court went through an analysis in which this court talked about recently in U.S. v. Planker, 105 Fed Fourth 996. The property-based approach and the privacy-based approach, but then the court said that the touchstone of the Fourth Amendment is reasonableness. And nothing's more reasonable than when someone goes into the bathroom and you see them go into the bathroom, you don't follow them in. And it's that simple. You just don't follow them in. It's just common courtesy. And I don't know how else to put it. There are cases that the government has cited where courts have found that police officers can conduct searches in bathrooms. In every one of those cases, something is different. There is a case that they cite in De La Sera, where the court found that Mr. De La Sera didn't do anything to manifest an expectation of privacy. In Boynton, the officers who entered the bathroom didn't know it was occupied. Here they knew it was occupied. Obviously, if you don't know a bathroom is occupied, then someone can't have an expectation of privacy, or the officers aren't violating an expectation of privacy if they don't know it's occupied. The other case that they cite, the door was open. So no one has an expectation of privacy if the door is open. If you look, there are cases where people are in toilet stalls and you see the feet in the stall, and the courts say there's an expectation of privacy in the stall. But if you can see through the crack into the stall, there's no expectation of privacy what you can see through the crack. There are cases that say that if you can see in a window into a bathroom, there's no expectation of privacy. But if you have to climb up somewhere to see into the window, then there is an expectation of privacy. Here you're in a closed bathroom. It can't be any clearer. I don't know, are there any other questions?
No, we get it. You're perfectly clear. Okay, we'll give you the rebuttal time if you need it, though.
Thank you.
Yep. All right, let's hear from the government.
Good morning, Your Honors. Starting with the last point that he's making. Everything in his argument seems to turn on the officer seeing him go into the bathroom. So, and I think he almost conceded that if the officers hadn't seen him go in, he wouldn't have an expectation of privacy. That's not how the analysis works. The analysis under Plancart, under Lewis, it's a two-step analysis. And it shows that a defendant does not have an expectation of privacy protected by the Fourth Amendment in an unlocked, out-of-order public bathroom. The first step is there a subjective expectation of privacy? And there is not when you don't even bother to lock the door, because anyone could have entered, as the court recognized. And the main factor that this court and other courts point out that goes to the subjective expectation of privacy is whether they made any effort to protect themselves, to protect that thing. So in Boynton, for example, the cases he just cited, De La Sera and Boynton, in De La Sera, the door's just shut. I mean, it's not locked. And the court says by not locking that door, when the officers came in and saw the drug deal going down, they might as well have been doing it in a public street, because anyone could have shown up and opened that door. In our case, what if those officers hadn't seen him and walked past that door, and it was the other officers who came in later, or a store clerk or anyone who didn't see him go in and open the door? All of a sudden he has a right to privacy, not under the case law. And in Boynton, I think is almost exactly like this case, because in Boynton, he's actually even pushing. There's two people happen to be in this single occupant stall, and one of them's pushing against the door, and the officers push through, and the court says, he didn't ask that guy to hold the door shut. He didn't do anything to protect his privacy. I think in that case, the door didn't even have a lock on it. So the bottom line here is there's been no effort by this defendant to ensure his privacy in an unlocked, out-of-order bathroom. And then even if he did have a subjective interest, there is one case out of the New York State Court that says even just a shut door gives you an expectation of privacy, presumably at least a subjective one. Even if that were the case, as the district court found here explicitly, it doesn't apply for Shirley when it's an out-of-order bathroom. Now, it may be true that if you really have an emergency and you have to go and you run in there, sure, you have to go, you run in there. But you know what? You know anybody could be coming in because it's not locked and it says out of order. So you may be doing your emergency thing, but you've lost that sanctity of righteous privilege that the defense is talking about when you go into an out-of-order bathroom. And in fact, the police officers noted in particular during their testimony at trial, it was unlocked and it said out of order. So, you know, their presumption, rightly so, as a matter of fact, was that it wouldn't be used for this private excretory function. That
So
would give.
it sounds like what you're saying is, look, before you know it, the federal reporter's going to have a whole bunch of bathroom cases in it, and let's just take them one at a time. You know, no broad categorical rules. That's very antithetical to the way the Fourth Amendment works.
But I think, as Judge Lee pointed out when he made this, or the court pointed out when it made this ruling, that is how the Fourth Amendment works, at least in this context. So there's two kinds of approaches, right, as this court has recognized, and in Placard in particular, as defense counsel said. There's the property-based approach, and that's what applied to the package he's talking about, or to the hotel room that the maid can go into. It's based on you have a property interest there, and that gives you extra protection. You don't have to come in here and establish your privacy right. But then there's the privacy approach. And the privacy approach has this, was there a subjective expectation, and was that expectation reasonable? And as the court said, I'm not making a blanket ruling here that every time someone doesn't lock a door to a bathroom, there's now not a privacy interest. What I'm saying is, what the court is ruling, not saying, but ruling is, that when it's an out-of-order bathroom in a public space and it's not locked, you do not have a protected Fourth Amendment interest.
Yeah, I mean, look, there's definitely a difference between the parties on the application of law to fact here, but there's not that much difference in terms of the privacy-based strand of Fourth Amendment law in bathrooms, because Mr. Greenberg is right. We can hypothesize, and I'm sure you'd agree, all kinds of fact patterns where there's a Fourth Amendment violation involving a bathroom.
Sure, of
Plenty
course
of
there
them.
are.
Yeah.
And I would say, Your Honor, to your point about it being nuanced, when you look at the Stahl cases, they're very nuanced. What you can see from the general area, you know, in the cases we cite in the brief, they're all nuanced. So I give that it's nuanced, but the nuance here all points to the defendant having no privacy interest in that bathroom.
I mean, this may be even nuanced in one additional way, that it's a single occupant bathroom, and your briefs are very good on this. I mean, it's very clear from the fact pattern, but it may be different if it's not.
It may be.
If it just has a little picture of a man or whatever there, and you think, well, it's not clear to me it's single occupant, so I'm going to walk on in.
Well, and that's the other point here. How is this clear that it was single occupant? If you look at the video, which we've supplemented the record with, I'm not saying this wasn't single occupant, it absolutely was. And there was another bathroom that didn't have an out-of-order sign that he could have gone into first, which I think is also telling here. But
well, that's a fact that's helpful to him. But I think
yes.
it's clear from that little sign on the door that has like a man/woman that it's a single.
Forgive me, Your Honor, because I didn't notice that in the video.
You know what I mean? The little picture on the door of the bathroom.
I just remember the out-of-order sign.
Yeah.
So I guess when I saw it, I didn't focus on that. So maybe it does show that, in which case it does indicate it's single occupancy. But I would say in this case, it's irrelevant. It's irrelevant because it had an out-of-order sign. It's irrelevant because he didn't lock the door. And it's particular. I guess what concerned me here is any analysis that now focuses on whether he was seen going in. Because that is a step in the analysis that seems to be the crux of his argument, that yes, there's mention. He'll be able to come back here and tell you, but it's mentioned in this case that they saw him go in. That may be the case. But in none of these cases is that a major function in the analysis, nor in cases where he's not seen to go in does it function to go in the analysis. And it just seems that whether you have a right to privacy in a situation cannot turn on who happens to observe. Because if it does, then, then the whole idea of a subjective and objective, that test doesn't make any sense. And I would just also add in one other point, and I think we've made it clear in our brief in the cases we cite, the burden in this to adduce facts that he thought served him or to put them in issue was on the defendant. It was not on the government, because the burden for the protected right is on the defendant. Once that right's established, it's definitely the government's burden to show an exception or to show that it was, that his rights weren't violated. But establishing the right was on the defendant. So unless the court has any other questions,
Okay.
the government would ask that you respectfully affirm the conviction and sentence.
Okay, thank you, Ms. Greenwald. Mr. Greenberg.
And I just want to point out, by focusing on this argument, we're not certainly abandoning the other two arguments. This is just more interesting to argue.
Yeah, sufficiency, and there's something, the Second Amendment.
The Second Amendment, which I think the court has probably heard enough times, that, and I think has a case that it's considering. When counsel says that, well, first of all, before I get into it, my associate pointed out that the government conceded in their opening statement at the trial that Mr. Scott did not fit the description of the alleged robber, although the witness then tried to make it sound like he did. So I don't even think that was an issue at the trial. But the government talks about whether Mr. Scott expected anyone to come in or not. Mr. Scott was certainly engaged in activity when the officers did go in, which would be indicative of someone who did not expect anyone to come into the bathroom. He would not be hiding something in the ceiling if he was expecting people to walk in the bathroom. I know that the district court judge said that he was hiding something in the ceiling, which showed that he expected someone to come in the bathroom. I think he was hiding something in the ceiling because he expected that when he was going to come out of the bathroom, that since there were police officers there, he expected they would do what they often do on the West Side, which is search people randomly. Counsel said something about he didn't do anything. He didn't make any effort to protect his privacy when he went in the bathroom. Well, he did. He shut the door. That's what people do when they go in the bathroom. That's how they protect their privacy. And then she said, well, what if the officers didn't see him go in the bathroom, and officers who came in later had come in, and then they had walked in and they had gone and opened up the bathroom door? And I think we'd have a weaker position if that were the case, but that's not the case. And we could have all sorts of hypotheticals about what ifs, and what if some patron had just opened the door and seen him doing that and then called over an officer and said, hey, look what this guy is doing. And then we wouldn't be here at all. Because,
but doesn't that all go to whether or not there's a subjective expectation of privacy?
Well, sure, except we're dealing with what the police officers saw. And police officers, just like they benefit in cases by their observations, they're also constrained by their observations. And here, their observations were that they saw him go into the bathroom. So they can't now say, well, what if we didn't see him go into the bathroom? Then in that scenario, this search would be perfectly lawful. They can't say that. Just like they can't say when they burst into a house without a warrant, well, what if we did have a warrant? Then the search would be perfectly lawful. I mean, we can't deal in those kinds of hypotheticals. That's not how we look at these cases. The fact is that they saw him go in, and then they went bursting in after he went in. And I don't think that we want a precedent that says that the police can do that. If there's any further questions?
Okay. Mr. Greenberg, am I right? I see here on our calendar queue that you accepted this on appointment.
Yes, Your Honor.
Yeah, we very much appreciate that. You've done a fine job for Mr. Scott. Thanks to your colleague as well, as always, to the
Thank you.
government. And we'll take the appeal under advisement.
Thank you.
Our third argument of the day is in appeal number 242731, CCP Golden and others versus Kevin Breslin. Okay, Michael Breslin, not Kevin Breslin, Counsel Michael Breslin is here in the courtroom. Good morning.
Good morning, Your Honors. I am Michael Breslin of the Law Office of Michael E. Breslin in New York City, Manhattan, and Wyckoff, New Jersey. I represent the defendant appellant, Kevin Breslin, who is my brother, in this matter. And we're here to discuss the underlying case where two main questions are, did that court have subject matter jurisdiction over that action? And the second issue is, did the district court err in its award of a $22 million damage award against Mr. Breslin? We think the answer to both of those is yes. They lacked subject matter jurisdiction, and the error in the award was incorrect. It is undisputed that at the onset of the litigation, there was no complete diversity between the parties. There were two parties, one of the plaintiffs, the Sabra REIT, as well as one of the named defendants, William Burris III, were both citizens of California. Now, there was a mistake at the filing of the complaint, because I think originally the plaintiffs thought that he was a resident and a citizen of New Jersey, along with his father, and he used to be. But over time, he had moved over to California. So at the time of filing, there was no complete diversity, and that's undisputed. Now, what plaintiffs did right away is, once they realized that situation, they moved to dismiss Burris III through a Rule 19 motion, which was brought to the court. And in order to dismiss a dispensable or dispensable party, my bad. There has to be an analysis by the court of whether there has been equity and good conscience in making that determination. Now, when we review the transcript of that proceeding, there's no evidence that there was any analysis whatsoever. And at that point, Mr. Breslin, my brother, was appearing pro se, or hadn't really actually gotten involved in the case yet. So he was pro se, so he wasn't there to question that. So there was no real factual determination other than the affidavit provided by the plaintiffs. So I think that the main issue here is, was that dismissal of Burris III appropriate?
We see all the time, Mr. Breslin, in your experience litigating, you probably have too, where you'll plead in good faith diversity, complete diversity, and then it'll lo and behold, it'll show up you have a non-diverse party, and non-diverse party is dismissed to maintain diversity jurisdiction. And so at that level, that looks like what happened here with William Burris III being dismissed. And then I think from there the argument goes was he a necessary and indispensable party under Rule 19A and B, correct?
Correct.
Okay. But we have joint and several liability under these contract provisions, correct?
Correct.
So isn't the whole concept of joint and several liability that you can recover in full from one obligor under a contractual obligation?
That is true.
So if that's the case, why does the part of your brief that I paused on is why therefore is Burris III a necessary and indispensable party? Because if a judgment is entered against Kevin Breslin, he in turn, through indemnity or contribution, can seek to recover from the other obligors under the contractual arrangement, correct?
That is correct. I think that the reason that Mr. Burris is indispensable in this case is that, based on the terms of the guarantees, there's two guarantees, the Chilton and the Chilton lease, master lease. Mr. Burris is deemed to be conclusively bound by any judgment against any party under joint and several liability. Now, the problem is he's not there to defend himself. And sooner or later, the plaintiffs will have to go after Mr. Burris, and they're going to find him in California.
Yeah, I think the challenge, you're clear on that in your brief. Here's the challenge, I think, for Kevin Breslin. preclusion law, at least as I am familiar with it, is not turning upon the terms and conditions of contracts. So I think your observation is accurate that Burris III would be on the hook contractually, but whether a judgment entered in the Northern District of Illinois has preclusive effect against him, where he's not a party, where he's been dismissed, is not turning upon any condition of the contract. It's turning upon other principles, the principles that apply in preclusion law.
Yeah, well, I think if he is sued again in California, the risk is that he is going to be bound by that contractual provision and prevented from defending himself. So again, he's in a situation where this could go on for another couple of years, and he's still bound by a judgment that was incorrect.
Yeah, we'll see what Mr. Williams says. I'm not sure your adversary agrees with that.
I'm sure.
No, I think they might say it's not going to have preclusive. That judgment's not going to have preclusive effect, because Burris III is just not a party in the Northern District of Illinois.
Well, and I think the other issue I think we're going to have here is when they do go after him in another location, presumably California.
Burris III.
Burris III.
Yeah.
It could very likely, and most likely, will have a different type of a judgment, different amount, and then he'll be sitting there with two judgments. He'll have a judgment based on the contract in this proceeding, as well as another judgment in California, which most likely will not be the same judgments.
Let me back up, and the question with Rule 19 is also, can it be waived? Typically you can't waive jurisdiction, but this is a little bit different because a party is dismissed, jurisdiction is restored, there's no objection, it's essentially an agreed motion, or at least a motion that is unopposed. And in Mucha versus King, we suggested that there is waiver when you don't object to such a motion. So what's your position on waiver?
Our position is that you have the ability to oppose jurisdiction until appeal. Even though it wasn't raised at the lower level, it can absolutely be raised until the end. And we cite Levin versus the Attorney Review Board for that proposition.
I understand the arguments in the brief, and your opponents make an argument based on the text of the rule. But since we've said in Mucha versus King that there's waiver, is there a way that you're distinguishing this, or telling us to overrule that, or is there some subsequent case that you'd like us to look at?
I think we should overrule that because it's, if there never was jurisdiction, we can't manufacture it here, and that's what the plaintiffs have done. By dropping Burris III, they manufactured jurisdiction that did not exist at the time of the filing, and we should be looking at the factors of, would his absence prejudice him? And I think the answer is obviously yes. And could this court shape a relief that might balance that and protect him from that? And then also, and most importantly, there's an alternative remedy by bringing this case to state court that will adequately serve all parties. Right now he's out of it. He's got a judgment he didn't defend himself in, and this goes on and on and on. Whereas if you bring this in state court, he could defend himself, and frankly, that's where the guarantees mention specifically this should be litigated in state court. And I think that avoids this problem where all parties can be in one place and then this issue gets resolved, as opposed to having a judgment out there against a guy who wasn't there to defend himself.
Yeah, how are you not, maybe you're not, but help me on this. How are you not arguing for a rule that in a situation where you have joint and several contractual obligations that a plaintiff wanting to sue for breach has to name everybody? For the case to properly proceed in diversity jurisdiction in federal court.
As a general matter, that is correct. That under joint and several liability, you don't have to name all the plaintiffs. But in this case, it's really the opposite, because from the start of the case, Burris III was part of the case, and only when they realized that there was an error on the citizenship that they're trying to have him removed.
I see. So suppose it was different. Suppose that the lawsuit commenced and the only defendant was Kevin Breslin, and there's no question about diversity then. Would you argue it's problematic because the other obligors are not defendants?
I would argue that. But I think that in this case, I mean, I think when you go to the key cases, which are Newman Green, which does open the door to a possibility of having Burris III removed or dismissed. But on the other hand, Stay Right, the case would preclude that from happening, and it should only be done in very, very specific situations after weighing the equities. Now, it's very, very clear here, based on the record, because I wasn't there, that no analysis was done at all. So there's no analysis of equities, no analysis of good conscience that would lead us to understand that the lower court went through that analysis. And I think if they did, they would see that right now Burris III is in a bad place. His absence is prejudicing him, and there is a very viable alternative of moving this case to Illinois State Court as the contracts provide.
Can I shift gears and ask you a question about the damages?
Sure.
Okay. The one of the things that your client did that makes the hand that you've been dealt difficult, in my view, is violate the Rule 56.1 requirements in the district court. All the facts that his adversary alleged were accepted at summary judgment. You've seen that in the district court opinion. Okay, when it came to the merits, though, I mean, he may have said enough. Kevin Breslin may have said enough to preserve his objection to the $5.8 million of accelerated rent and the $1 million on liquidated damages, but it's far from clear to me that he lodged a meaningful challenge to some of the other components of the damages award. For example, the $10.3 million of lost value. You say a little bit about it in your briefs, but just a little bit.
Sure, no, understood. The plaintiffs brought in only at the last minute, and that was really on the reply brief for summary judgment. They brought in an affidavit from Peter Nyland, who's an officer for the plaintiff, and he ran through his numbers, and it was, he said he talked to these people, who talked to those people, and they look good, but frankly, there's plenty of things that look good on AI that maybe is not right, and that's where Mr. Breslin needed an opportunity, or deserves an opportunity, to review those numbers, to review those assumptions, especially in regards to mitigation of damages, which, when you look at it, doesn't look like it actually happened. The property was sold for $1 million, and they're saying he had $22 million of damages, and there's a lot of factual issues there.
So hold on, I want to make sure. Is your point that Mr. Breslin, he's certainly aware of Peter Nyland's declaration?
Absolutely.
Okay, but he had no ability to offer evidence in response to it?
Not in summary judgment, because it only came up. I think the issue was raised at opposition, and
right. But he has a chance in reply, right, to respond to it, or alternatively to move to open the record.
Well, in that case, that was not done. Okay, that was not done. But
You want to save your time for rebuttal? It's up to you. If you.
Yes, please.
Okay. I mean, we're gonna give you rebuttal time. I don't want to interrupt your thought. If you
Sure.
had another point to make, go ahead.
Yeah, it's just that Mr. Nyland's document was self-serving, was never reviewed by the court, and is really just looked at like, looks good, sounds good. Let's assess him with $200 million. And there's too many issues there that really need to be fleshed out through an analysis by the court, and that was just never done. And I think that that's just not appropriate. And I think because of the nature of when it was brought in, it should not have been admitted at summary judgment, in that it was brought in at the reply. It was hearsay, and not subject to an exception, and as a result should not have been considered at summary judgment, which leads us to this. the plaintiff did not have jurisdiction, and these damages were inappropriate and were awarded in error. Thank you.
Okay, we'll give you a minute on rebuttal.
Thank you.
You're welcome. Mr. Williams, good morning.
Matthew Williams for the Appellees. May it please the court. Your Honors, beginning with the Rule 19 issue, I think Newman Green basically disposes of this issue entirely. Not only does it say that a non-diverse party can be dismissed to save diversity, this is a direct quote from Newman Green. Given that all of the guarantors, including Bettison, are jointly and severally liable, it cannot be argued that Bettison was indispensable to the suit. I think that basically handles that argument. Very clear that Mr. Burris was jointly and severally liable. The guarantees expressly stated that. To the extent that Mr. Breslin is now arguing, hey, there's a provision in this guarantee that says that Mr. Burris agreed to be bound by findings in another action. First of all, that's not a judgment in this action. Obviously, I don't have a judgment against Mr. Burris III. I don't have anything to execute on. I would have to file a new lawsuit. That provision is a contractual provision, and on top of that, it is a contractual provision that has Mr. Burris III saying, you don't even have to sue me in the other lawsuit. So it's anomalous to say he is now indispensable in this lawsuit because of a provision he signed saying, you don't have to sue me in that lawsuit, and I'm going to agree to be bound by what happens there.
Well, do you agree that the preclusion analysis doesn't turn upon the terms and conditions of the contract, does it?
It does not at all. The preclusion analysis, I don't think I have any argument that he is precluded under what are called standard principles of law. To the extent I have any argument, it's because of the terms of the guarantee when I seek to enforce it, and that would be litigated, and he'll have a full and fair opportunity to litigate that. He has not had the full and fair opportunity here. That's agreed upon, therefore standard principles of collateral estoppel and issue preclusion don't apply. Unless there are any further questions on the Rule 19 analysis, I'll briefly address the mitigation and damages arguments. First of all, just to be clear, the numbers were included in terms of the damages. All of those were included in the initial motion filing. Mr. Breslin very clearly had an opportunity to respond to that. He chose not to by asserting the Fifth Amendment. That is on him, but it's not that there wasn't evidence of that presented, and it's not that he didn't have the opportunity to respond to that. Even on the mitigation, first off, I think the better of the law would be that because a guarantee is a separate contract, which Illinois law does support, the Armbrister case is a good example, that it is an affirmative defense mitigation. Nonetheless, that evidence was put in. There's no reason to think that Mr. Breslin would have done anything other than assert the Fifth Amendment as he did throughout the case. He didn't move to strike. He didn't move to file a surreply. He has done nothing to say, here's what I could actually offer that would rebut this. He undertook no discovery in the underlying case. And so, notwithstanding the fact that it was submitted in the reply because it was raised in the response, there's almost no reason I can see of to ignore that evidence, and the court properly took it into account.
Can you walk me through the calculation, though, for the diminution and where in Illinois law that's coming from?
So I would, Judge Shader issued an opinion in the National Healthcare Finance case. It is a district court case, obviously not Seventh Circuit, but that talks about, okay, here's what contract damages are for leases, and here's what naturally flows from them. And I think it's going back to those basic contract damages that get to the diminution in value. Here, the underlying leases said the tenants were going to take care of the properties, keep them in good repair and condition, to continue to pay rent, to continue to operate them as nursing homes. Once the facilities were put into receivership and lost their licenses, they certainly lost a lot of value. They had the value as operating businesses. They weren't in good condition. My client, as you can see from the mitigation evidence, tried to go out and find new tenants to lease or to purchase, was unsuccessful in doing so. And so the idea is all of this has been lost. What would we have gained? What would we have had the tenants actually complied with the leases? Had they operated these facilities until the end of the lease and then handed us back good condition, working nursing homes? In terms of the actual calculation of it, it goes into how nursing homes are valued, which Mr. Nyland works for a real estate investment trust that invests in healthcare properties. He explains that we value leases in large part based on the rent that would be paid. So that's how the real property tends to trade. And he basically sets out the calculation, which is apply a capitalization rate to the amount of rent that would be paid, and uses the rent that the tenants agreed to pay here. So that's how the actual numbers flow, but the underlying basis on why that value is owed is because that's what my clients expected to get back at the end under the terms of the lease.
Yeah, I think what you're basically saying is just suppose a different fact pattern, and suppose a fact pattern where what was it, 4 facilities or something, where the 4 facilities were completely ignored, not maintained, and fell into a state of dilapidation in breach of the contract. You could have an appraiser come through, right, and assess what it would take to bring them back up to speed, and repair damage, et cetera, that way. And if that number added up to $10.3 million, it is substantially, or in substance, it's the same of what's done here. This is just done through a capitalization calculation.
I think that's correct, Your Honor. There are different ways you could think about it. Another way to think about it that actually would have been more advantageous to my client in terms of the ultimate number is to look at what the tenants themselves signed a purchase option agreeing to buy these properties for, and it was $15 million. So the future value discounted back to present value is about $5 million, less than that. It comes out to $10 million. There's different ways you could do it, but at the end of the day, all it is doing is looking at, here's what we expected, what are the damages to get us back there?
And they got $1 million out of it at the end, right?
They got $1 million out of it at the end, minus some costs of the transaction, all of which were taken into account in the damages calculation that was
Can I ask you about the one part of the calculation that I do pause on a touch is 2 of them. The liquidated damages. Liquidated damages are tricky, and they may be appropriate in an instance where you really can't compute compensatory damages, or it's just exceedingly difficult to do that. But all of these other components are essentially compensatory. So why is the liquidated component, the $1 million, why is that not essentially a penalty or tantamount to a penalty?
The $1 million. So I think the law says, look, as long as that is a reasonably calculated amount, we're not going to consider it a penalty, even if you're able to ultimately calculate,
but
because
it's
you've agreed
to approximate damages, though. That's the difficulty for you, right? And you have all these other elements of the damage calculation. There's a whole bunch of elements other than liquidated damages, as you know.
That's correct. Yes. I think the idea, though, is that was agreed upon ahead of time as a way to approximate, and Illinois law does enforce that, even where, as far as I can tell, even where the other damages end up being calculable. That said, if this court were to reduce the award by the amount of those liquidated damages, I could understand where that comes from in terms of finding them somewhat duplicative.
Okay, help me out then. The only final question I have on this is on the acceleration of the unpaid rent that way. And the reason I'm asking you about that is because it seems a little bit counterfactual to me. And that is that had the leases run their course, they would have run through January of 2026, if I'm right about that.
Correct.
Okay, but we know that that's actually not what happened, nor was it what the parties had agreed would happen. And what was slated to happen is that there would be a sale right, in March of 2019?
That's correct.
Okay, and so had the sale occurred, ownership would have transferred, right, of the facilities. There wouldn't have been any more rent being paid.
That's correct, and I think this goes back to my comment earlier about when you look at the way the diminution in value was calculated, it was advantageous to the tenants as opposed to my clients under this damages calculation. If you wanted to look at it another way, I think you could use that 15 million plus, I think it was $16 million number that was agreed upon. And if you were to do that, I would agree that using the accelerated rent at that point wouldn't make sense, because then you're saying, okay, under this contract as kind of looked at in that sense, but now you've got a $16 million number instead of a $10 million number. So it probably comes out about the same between the accelerated rent discounted back to present value and the diminution of in value discounted back.
But why would you be why would not you, but why would your clients be entitled to both?
I think it's one or the other, and it was framed as one or the other because there was no. As I said, I could see where you can get to the idea that the liquidated damages are duplicative, but the $16 million was never included. So the way it was calculated by my clients is, okay, if the lease had played out, the sale had not occurred, they had breached the purchase option, but the lease had played out, they would have paid rent through the end of the lease, and then we would have had this working, good condition set of 4 facilities that are handed back to us, and so we would have had the value of it at that point in time. Let's subtract out what we actually received. Another way to look at it may have been, okay, there's a sale that would happen in March of 2019. It would be for $16 million. Rent after that wouldn't occur, and so you wouldn't have that acceleration of rent, but you would have $16 million in March of 2019. I think fundamentally, those numbers probably come out pretty close. To me, it's two sides of the same coin. My client chose the accelerated rent and the net present value kind of extended out at the 2026 value of the building, so discounted back to present value, as opposed to saying, hey, if the sale had gone through, we'd have got the $16 million. If there are no further questions, thank you.
Yep. Thanks to you, Mr. Williams. Mr. Breslin, we'll give you the minute of rebuttal.
Okay. Plaintiff appellee is relying heavily on Newman Green as supporting their position that Rule 19 allows an easy dismissal of Burris III. I think that's extremely broad and paints a very wide brush, where I think that under Newman Green, the opportunity to do that should be sparing. And it really requires a review of the facts. And I think what's unusual about this case is the contract. The contract provides for conclusive liability that isn't always going to be the case. So I think you really have to look at the equities and do a real Rule 19 analysis and say, was it appropriate in this case? I think especially when there's alternatives, a good alternative, which is the state court, I think that some of these cases where they're stuck there because there's nowhere else to go. Here, we could easily go to state court, and I think that's very viable. On the damages, they did not really prove their mitigation efforts. It was never cross-examined. It was a self-serving document, and that's, it should be ignored. It's hearsay, not allowed under summary judgment, and at the end of it, while the plaintiff appellees defended their figures, I think it's clear that the numbers that they're coming up with are very uncertain, and could be anywhere. I think you throw out a 9.5% cap rate, no one knows what that is. Should that be 2? Should that be 30? No one knows, because we never had that conversation. And that is where this should be remanded to the state court for a fuller analysis on that issue, if we even need to get to that place, because they didn't have jurisdiction to start with. Thank you. Your
Okay.
Honors.
You're quite welcome. Mr. Breslin, thanks to you. Mr. Williams, thanks to you. We'll take the appeal under advisement. Our fourth argument of the day comes in Appeal 24-21-23, Frankie Nelson versus Cook County, Illinois. Mr. DePasquale, good morning. Whenever you're ready.
Good morning, Your Honors, and may it please the Court. My name is Joseph DePasquale. I represent the appellant Frankie Nelson. The District Court's ruling granting defendant's motion for summary judgment should be reversed and the case should be remanded for two reasons. First, McDonnell-Douglas burden-shifting framework was rigidly applied here at the expense of the holistic analysis called for under Ortiz. And second, a fact finder could reasonably conclude that sex motivated the adverse treatment in that plaintiff did double the work as her male counterpart but did not receive the pay or the recognition. As to the first point, McDonnell-Douglas is a framework for analyzing circumstantial evidence in an employment discrimination case. First step being plaintiff shows a prima facie case, that she's a member of a protected class, that she performed to expectations, she suffered an adverse employment action, and similarly situated individuals outside of the protected class were treated more favorably. The plaintiff puts that forward, the employer then, the burden shifts the employer to provide a legitimate, non-discriminatory reason for the adverse action, and finally, if that's shown, the employee has to show that those reasons are pretextual. They're not worthy of being believed.
Is the only claim before us, Mr. DePasquale, it's the Title VII claim, right?
Yes, sir.
The Equal Pay Act claim is not before us.
That was dismissed earlier in the case, and that is not before this
Okay,
court.
here, help me out on this. This is what I've had trouble with on the Title VII claim. It seems that what your client is saying is that she wanted to get paid as if she was a director, correct?
Yes.
At the pay rate of the director. Okay.
In
but
part, she would have liked to have done the work.
I know she
and
wanted the
received
title
pay.
of director. Okay, but this is about compensatory damages at this point, and so she wanted to get paid as a director. But in the work that she did do, she received overtime pay because she was working a lot. And when you add up her total compensation, she actually made more than she would have received was she the director. So I'm not sure I know what is the monetary recovery that she's seeking on appeal.
The difference of what she should have been paid for the work that she performed. Henry White.
Is it a failure? But hold on. She's not claiming, is she, that she worked overtime and was not paid?
Correct.
Or that she worked hours and wasn't paid or something like that?
Correct.
Right, it's a differential claim. She's saying, I wanted to be paid at the rate of the director. But she would have made less, not more.
And factually, she was performing two jobs and only receiving one paycheck. That I think is the distinction that perhaps needs more clarification. She was doing work as building services supervisor, which involved managing the housekeeping staff, directing the housekeeping staff, and was sharing the duties of director of environmental services with Henry White. She was handling mainly the operations portion of it, while White was handling the administration portion of it. But she was doing those duties in addition to her building services supervisor duties, which included getting the hospital ready for the Joint Commission, cleaning, stripping floors. I mean, she was not only directing the housekeeping staff, she was on the ground with them, making sure that everything was up to code, up to status.
I get that theory, but so what you're basically saying is, look, she pulled in a lot of different directions. She was doing a ton of work. She was basically doing a second job, right? But
Yes.
for all of the time that she was there, she was paid for that.
Yes. The distinction here, again, being Mr. White, he was being paid overtime for extra work that he wasn't doing. He was doing just the administrative work with regards to Director of Environmental Services. He was not performing any of the building services supervisor duties that come with the title. So all those duties fell on Ms. Nelson, whereas he was doing basically his office job, regular hours, and getting paid overtime. So Ortiz, so whereas McDonnell Douglas provides a framework for analyzing these things, Ortiz represents a broader principle that the question is whether a reasonable fact finder could conclude that the plaintiff would have been treated better if she had a different sex based on the totality of the evidence as a whole. So rather than the strict first plaintiff prima facie case, then employer, legitimate non-discriminatory reason, and then back to plaintiff for pretext, this is kind of brings it back to first principles, basic principles. It is on the plaintiff to show that a protected characteristic was the basis for the adverse action that she suffered. Here, the district court looked at the evidence exclusively through a McDonnell Douglas lens, which distorted the view of the totality of the evidence, which again relates to her actual duties performed and pay earned versus actual duties performed by Henry White and what he received for pay.
What's the best evidence you have, though, that even assuming what you're talking about is right, what's the best evidence you have that any pay differential was based upon her gender?
Mr. White was male, not a part of the protected class. The other individuals who held the position of Director of Environmental Services, again, were male. I believe it was Brown. I apologize, I forget the other last name of the other individual. So all of these males were permitted to either get the title and the pay, or they were permitted to use the title, do the work, and ignore their other responsibilities as building services supervisor in the case of Mr. White. I had reserved 3 minutes for rebuttal. Unless
fine.
your honors have for additional questions, I'll reserve.
Okay, very well.
Thank you.
You're welcome. Mr. Yoon, good morning.
May it please the court, Assistant State's Attorney William Young, on behalf of Defendant Appellee Cook County. This court should affirm summary judgment for 2 reasons. First, no reasonable jury could find in favor of the plaintiff because plaintiff cannot identify a similarly situated comparator. And secondly, as this court just noted, plaintiff was simply paid more than her alleged comparators. Before going to my 2 points, I think it's important to address plaintiff's position. He states that under Ortiz that there is no similarly situated comparator necessary. And while that may be true in a different fact pattern, as appellant just stated, his best evidence was the pay itself. Under that fact pattern, where it's only pay, the only evidence that's offered to the court is the pay. As this court held in Palmer versus Indiana University, when pursuing an unequal pay claim, the plaintiff must show that the protected grounds caused the disparity in compensation. And in applying Ortiz, this court stated, but an unequal pay claim begs for some comparator evidence. Unequal to what? And there, plaintiff's argument hits a glitch, again quoting Palmer. Well, plaintiff's case here hits the same glitch. Unequal to what? There are no similarly situated comparators. As this court held in Weaver versus Champion Pet Food, it is well settled that speculation may not be used to manufacture a genuine issue of material fact. Saying so at summary judgment does not make it so. That's Patel versus DeJoy. I'm happy to talk about all of the alleged comparators individually, but there are some universal truths. First of all, plaintiff in the record, on record 85, plaintiff never supervised any of the alleged comparators. That's to say, plaintiff does not know what they did on a day-to-day basis. Plaintiff does not know the qualifications of Director Gordon, the qualifications of Director Jerry Brown, or the qualifications of Henry White. Plaintiff does not know the qualifications or the duties of the DES position itself. Most importantly, plaintiff never alleged she performed all the duties of a Director of Environmental Services. The court has no individual questions about any of the alleged comparators. Then we just point out that I would like to respond to plaintiff's argument that she did two different jobs, that she, during the Joint Commission, she was stripping floors, waxing floors, high dusting, low dusting. And while there's great dignity in that work follows the job description that was offered in the record of a building service supervisor, which has a high school diploma requirement, which is what she attained. The job description of building service supervisor includes direct supervising housekeeping staff, plan work schedules, observe that instruction safety rules are followed. Whereas a director position has a university degree requirement and encompasses administrative duties, such as consulting with Labor Relations Council to effectuate and enforce applicable CBA, collective bargaining agreements, proficiently navigate the county health record system, develop working relationships with external vendors and consultants, ensures compliance with all contractual obligations. Plaintiff points to Henry White, who is not a similar situation comparator because he has a university degree, a master's degree, and an associate's degree before he became a building service supervisor. He also sat in her interview when she came on board to Providence Hospital. He observed her work, performed a performance evaluation for her, and quite frankly, between 2002 and 2005, which is the alleged period of time, Henry White was paid less. He was paid less than the plaintiff. It is uncontested that the plaintiff in 2004 received a promotion, an increase in pay at an hourly rate. She was still eligible for overtime pay, which she received. And the Director of Environmental Services position is a salaried, non-union position. If there are no further questions, I would just briefly conclude. For the foregoing reasons, defendant appellee Cook County asked this court to affirm the lower court's decision granting summary judgment.
Okay, Mr. Young, very well. Mr. DePasquale?
Thank you, Your Honors. To address my colleague's couple of points. First, the issue is not only the pay. The issue here is that White and the plaintiff split the duties of Director of Environmental Services, but White did not perform building service supervisor duties while those fell entirely on plaintiff. While they may have been paid, Ms. Nelson was paid overtime for the work that she performed, in the sense that she was getting hours beyond the 40 hours per week. White was receiving that as well, but without doing the same duties, without doing his duties as building service supervisor, which was the title he actually held during that time. Another point brought up by appellee is that Ms. Nelson didn't have the requisite college degree that White and the other building service supervisors possessed. However, there's nothing in the record to show that this was a consideration for the county at Providence Hospital in any way. In fact, they had assigned her to do these duties even though she didn't have a degree or formal education that may have been necessary for someone formally holding the position. She was acting director or assistant director of environmental services along with White, and they had never made an issue of her education level. So unless your honors have additional questions, I thank you for your time.
You're quite welcome. Thanks to you, Mr. DePasquale. Mr. Young and your colleague, thanks. We'll take the appeal under advisement. Our fifth case of the day is in appeal number 232557, the United States versus Larry Jones. Yeah, Mr. Ackerman, nice to see you.
Court, please, I'm Alan Ackerman. Good morning. I'd like to say good morning, Judge Rovner, who is apparently being recorded or something.
Yep, she will hear that.
I have to say something about Judge Rovner very quickly. I was reading 17 Fed 3rd last week, and at the beginning of that hardbound copy, there's a beautiful portrait of Judge Rovner. So I would like her to know that I paid enough attention to say hello.
I'm sure she'll appreciate
Having said that, I represent Larry Jones. He is not a candidate for a good conduct medal. I don't expect to argue that. All I'm going to argue is he would entitled to a fair sentencing hearing. And in this case, the government presented two individuals, one a mass murderer who killed people at the behest of Big Don, and the other a drug abuser and drug dealer named Spencer. I'd like to talk for a moment about Big Don because nobody else talks about him, so I bothered to look it up. In my reply brief, or my opening brief, I forgot which, I recite his history. He was involved in huge drug deals. He pled guilty in this building to 18 CR 356 to a superseding information. The government, based on a plea agreement, filed a sentencing recommendation of 10 years for Big Don. R250 in that 18 CR 356 or 358. Lo and behold, docket R351 has a confidential sentencing memo. And lo and behold, Big Don does no time at all. Big Don, who has people murdered at the drop of a hat and provides drugs all over the West Side, all of a sudden walks. Time served, 1 day. That's it. Now, what does that have to do with Larry Jones? Because Big Don is mentioned frequently in the sentencing hearing for Larry Jones. Dante, whatever his last name is, I'll call him Dante, had a plea agreement with the government before Judge Durkin in a separate drug case where he acknowledged murdering 6 people, attempted to murder several others, and was a drug dealer besides. And besides that, he had a long criminal history. So after Big Don Walker, Walker Jr., Big Don's son, was murdered, all of a sudden Dante decides to be a government witness. So he turns around and tells the government about all his sins, and maybe he did, I don't know. For all the sins, he entered a plea agreement with the government for 20 to 30 years, or everything. Attempted murders, all that, everything he confessed to. He got a 30-year sentence based on the guilty plea. The 6 murders, 4 in Illinois, would have got him life without parole 3 times over. That's okay. And Mr. Spencer, who had his own drug organization, as he testified to, and who had drug suppliers, just like Dante did, other than Larry Jones, he got 70 months in custody, and he had a lengthy criminal history. The beauty of it is, for sentencing purposes, neither Dante nor Spencer had any record, any photographs, any ledgers, nothing at all. But the government had a Title III on Larry Jones, and interestingly, the Title III covered only the 9 counts of indictment that Larry Jones was charged with in 2020. So, there's this sentencing hearing, and the government has nothing tangible at all. Nothing. Not a shred of evidence, not a ledger, not a photograph, not a tape. What they have is Spencer and Dockett, Dante Dockett, and 2 plea agreements, and all they testified to is their corroborating plea agreements that are almost interlocking. And with that, the district court judge, a very fine judge, decided that they corroborated one another, and therefore, all this is about relevant conduct. He agreed he sold 178 grams of heroin, every count in the indictment, he agreed with that. And that's what he pled guilty to. And his lawyer argued, contrary to what the government suggests, his lawyer argued, wait a second, he pled guilty to the 178 grams of heroin. That yields about a 5 or 6 year sentence. He deserves it. Give it to him. That's fine. But the relevant conduct, Larry Jones disputes. He disputes it. And the dispute is real because we know when he pled guilty on July 19, I believe it was the date, or January 19, 2023, the judge stops the proceedings because he won't own up to the relevant conduct. I didn't do that much. The figures are wrong. Ultimately, it turns out that he says, okay, based on the fact that the judge tells him his lawyer can argue about it at sentencing, which his lawyer does. So our very fine opponents for the government have, in their answering brief, I believe from pages 23 to 30, I believe, that this was some wild scheme by the defense lawyer to get acceptance of responsibility. And that's why he didn't forcefully argue the relevant conduct issue. That's bogus. It's false. It's wrong. Now, did defense counsel argue temporal proximity? Did he argue off U.S. versus whatever it is? I mentioned it in the brief. Where the court goes through relevant conduct, including temporal proximity, and the fact that because somebody is a dope dealer and says they're a dope dealer and has deals on the side, that isn't necessarily relevant conduct. And in this case, it isn't, because the indictment had a very isolated period of time. August 6, 2018 to September 3, 2019. Those are the dates of the indictment. He sold heroin and committed money laundering. Okay. Everything else is relevant conduct. Mr. Spencer's stuff goes back to 2016 and 2017. No temporal proximity. Dante Dockett was back in prison in 2017.
Mr. Ackerman, let me interrupt you. You're getting into your rebuttal time a little bit, but having read your brief, your argument's clear.
Okay.
The difficulty that Mr. Jones has is that in his plea agreement, he agreed that relevant conduct could be considered. That's clear. Okay, I don't think that by agreeing to that, he was unable to contest particular facts and whether they fit within, relevant conduct or whether they don't, or was the credibility finding. But that's really that latter point is really the only issue, is it not, that he has before us because of his plea agreement?
The government did not satisfy its burden of a preponderance of the evidence by reliable evidence.
As to relevant conduct.
Exactly.
Okay, why don't we give you a minute on rebuttal, if that's okay?
Thank you.
Yep, you're quite welcome. All right, let's hear from the government.
Good morning, Your Honor. May it please the court, Michael Maione on behalf of the United States. The district court in this case correctly considered the defendant's entire scheme to distribute narcotics with his charged co-conspirator when it calculated his sentencing guidelines. Now, I'm going to take the merits of the decision to calculate the entire scheme as one scheme first, and then I'll address the issue that I think the court just raised at the end there of waiver, if it pleases the court. So, first, as the court knows, under the sentencing guidelines, courts do not consider only the offense of conviction. They also consider all acts that are in the same course of conduct or as part of the same common scheme or plan as the offense of conviction. In this case, the offense of conviction was, as counsel noted, a 13-month-long heroin distribution conspiracy between the defendant and an individual named Jamar Spencer, as well as a third individual named Marcia Fountain. In addition to the amount of narcotics that was dealt during that 13-month conspiracy, the district court also heard evidence at sentencing, largely in the form of testimony from Mr. Spencer himself, that the narcotics scheme between Mr. Spencer and the defendant was not only within that 13-month period, but from 2018 to 2019, but in fact began in 2016 with sales of marijuana, and then turned to sales of heroin in May of 2017 and continued until 2020. The district court rightly considered that entire single scheme, that entire single conspiracy between Mr. Spencer and the defendant as a single course of conduct or common scheme or plan because, first, it involved the same co-conspirator, defendant, and Mr. Spencer. Second, it involved the sale of narcotics in the same location, largely in the Austin neighborhood of Chicago. And third, because it involved the same means of distributing narcotics. Specifically, the defendant would front or sell narcotics to Mr. Spencer, who would then distribute those narcotics on those street corners in the Austin neighborhood of Chicago, which the defendant controlled by virtue of his position as a high-ranking member of the Black Pea Stones street gang, of which Mr. Spencer was also a member. This was a single common scheme or plan. It was a single course of conduct, and the district court did not plainly err by considering it as such when it calculated the defendant's sentencing guidelines. Turning to the issue of waiver, we've heard now today, and the court has seen in the briefs, that appellant now challenges whether his dealings with Mr. Spencer outside the time period of the offense of conviction were in fact relevant conduct. However, as has already been discussed today, in defendant's plea agreement, he stipulated not only that he had met Mr. Spencer in the early 2000s, and not only that he had sold both heroin, the narcotic that was at issue in the offense of conviction, but also that he sold to Mr. Spencer fentanyl, cocaine, and marijuana. He further stipulated that those sales were relevant conduct for the purposes of calculating his guidelines. What defendant didn't agree to, and I agree with appellant counsel on this, was the drug weights. The government included the particular drug quantities that the government intended to offer evidence of at sentencing of each of those drugs I just listed that defendant admitted that he sold to Mr. Spencer, but the defendant didn't agree that those weights were correct. So that was the state of play going into sentencing. Defendant at three separate points. First, in a defendant's version of his offense. Second, in his sentencing memorandum. And third, at the sentencing hearing, defendant advanced the argument that he was not in any way minimizing the severity of his offense, that he was not in any way minimizing the extent of his drug dealings with Mr. Spencer, but that he was only exercising his right to put the government to its proof of preponderance of the evidence of proving the exact weights that the government intended to offer to the court that the court should use when calculating the defendant's sentencing guidelines. And that issue was litigated, and that issue was resolved by the district court, which was well within its discretion to make its own determinations about the credibility of the live witnesses that the district court had before it, and did make those credibility determinations, and ultimately found that the government's the amounts of narcotics sold by a defendant to Mr. Spencer, as described in Mr. Spencer's testimony, were credible. And it used those amounts to calculate the sentencing guidelines as one common scheme or plan. That was defendant's right, and defense counsel could not have made it more clear that he was attempting to protect defendant's acceptance of responsibility under the guidelines when he only challenged the government's proof of the quantities and not the fact that the defendant had sold other drugs at other times than those described in the offense of conviction. That strategy was ultimately successful. Defendant received his acceptance of credibility credit over the government's objection, but it also, that conscious and strategic decision to follow that course also affected a waiver of the argument that defendant now makes, which is that this conduct that's outside the offense of conviction was not relevant, even though he stipulated that it was, in fact, relevant. Unless the court wants me to address some of the issues that were more tangentially touched upon in the briefs, I would conclude by asking the court to affirm the sentence.
Okay, Mr. Maione, thank you.
Thank you.
Mr. Ackerman.
Thank you for the minute. What the government didn't talk about is the lack of any proof of the relevant conduct other than the testimony of Mr. Spencer and Mr. Dante Dockett. Because there is nothing to support it. And if that testimony from Dante, a gangster since he was 15, Spencer since he was 16, if that's enough to put somebody in prison for 15 years or 16 years, that's what this case is. It's before the court. Thank you.
Mr. Ackerman, thanks to you. We appreciate it very much. To the government as well. We'll take the appeal under advisement.
Thank you.
Our sixth and final argument of the morning comes in Appeal 24-2014. Dennis Jones versus the acting commissioner, I believe, of Social Security. Okay, Mr. Sellers, nice to see you.
Good morning. May it please the court, counsel, Joseph Sellers on behalf of the appellant Dennis Jones. This case turns on two regulations in the commissioner's regulations. The first lays out what can constitute a medical opinion under the regulations, and the second lays out specific statements on issues that are reserved to the commissioner that by definition are inherently unpersuasive. The regulation defining the statements on the issues reserved to the commissioner is a exhaustive and specific set of language that has precise legal meaning that, if adopted by the ALJ from a medical source, would surrender the ALJ's authority to make those legal conclusions to the doctors. And the commissioner has strenuously restricted that type of abdication of authority. The other regulation is broader and less technically defined, and it lays out simply that a statement from a medical source can qualify as an opinion if it satisfies a two-pronged test. First, what the claimant can do despite their physical or mental impairments, and second, whether those physical or mental impairments cause work-related functional restrictions. The opinion at issue in this case by Dr. Runke satisfies that two-pronged test. He opined after examining Mr. Jones that Mr. Jones can only work as a cashier for 20 hours per week, and that his physical impairments prevent him from performing the physical functions of that job for any longer than 20 hours per week. That meets both of those prongs and should qualify his statement as a medical opinion.
Can I, this is an interesting issue. Can I ask you a question just to try to tease the legal part of this out a little bit? So let's just change one thing, Mr. Sellers, about Dr. Runke's opinion.
Sure.
Okay. And let's say that the limitations that Mr. Jones has would allow him to work 0 hours in the grocery store. So the only edit I want to make, hypothetically,
Right.
is to take 20 and make it 0. Okay.
Yeah.
All right. So in that situation, I think you would say, well, yeah, you bet Mr. Jones wants that considered, because that's pretty definitive that he can't work. If you can work 0, you can't work 1 hour.
Correct.
You can't work.
That would be
Okay.
a compelling statement from a doctor, especially Social Security's own examining doctor.
Okay. My question though is this. Okay. So let's suppose that we made that edit hypothetically. What is an ALJ to do with it? Okay. Even if you say it's a medical opinion about his capacity to work. So I'm agreeing with you.
Okay.
Hypothetically. What's an ALJ to do with it other than to say it's the equivalent of an opinion that he's disabled because he can't work? And that's an issue that's reserved to me.
Correct. And I think that's exactly what the ALJ would have to do with it under the regulations. Because when you limit a claimant to 0 work, and I think there's a district court case from this circuit that dealt with a limitation to 0 hours of work.
Yeah.
That is synonymous with a
Okay.
doctor saying, my patient is disabled.
Okay, that's interesting that you're saying that. So help us therefore draw the line. Because when we're talking about work, we're just a notional benchmark of 40, right? 40
Correct.
hours a week, just round it off
Yeah,
at 40.
correct.
Okay. So if he can only work 20, he can't work 40, he can't work full time. So how do we draw these lines then against the backdrop of that hypothetical that's in my mind?
I think the issue with the 0 hours a week is that it is so close to simply saying my patient is disabled that there is no real distinction between the two. But a doctor saying that my patient can work 20 hours a week, that's all his body will allow him to do, is a substantively different statement. Because it says he can still do 20 hours per week. He just can't handle more. And that's the first part of that medical opinion test, is what can the claimant do?
And would you answer that the same way if it was 5, for example, and Dr. Runke was saying, I think he can only work an hour a day, 5 days per week?
I think that would still qualify as an opinion, so long as the doctor also tied it to the functional physical restrictions.
Okay, I got it.
And the regulations do set out a fairly bright line test that if you use this language as a doctor, it's a statement on an issue reserved to the commissioner. If not, with the exception of things that are virtually synonymous with disabled, using the term disabled, as long as you meet that two-pronged test, you are proffering a medical opinion. And any medical opinion in the record needs to be considered by the ALJ and evaluated for persuasiveness. The ALJ did not even acknowledge Dr. Runke's clinical impression in this case, and therefore any of the government's arguments undermining Dr. Runke's opinion or that it was a statement on an issue reserved to the commissioner are barred by Chenery. And if there are no further questions, I'll reserve the.
I do have a question. How do we look at this in the context of an ALJ decision where the ALJ did an analysis and came to an RFC that was more restrictive than the doctor's?
In the sense that if the ALJ had considered, say, Dr. Runkey's opinion and said, it's persuasive, but I find the claimant more limited, that this court's case law is, more recent case law is pretty clear that if the ALJ finds the claimant more limited than any opinion in the record, then there wouldn't be much harm in not specifically addressing Dr. Runkey's opinion. But in this case, that wasn't what happened. The ALJ ignored the opinion and then found Mr. Jones more capable than Dr. Runkey opined. And that's why there is clear factual harm in this case. And that's why the ALJ's omission warrants remand. And I'll reserve the rest of my time for a vote. Thank you.
Very well. We'll hear from Ms. Schwartz.
Good morning. May it please the court. My name is Allison Schwartz, and I represent the Commissioner of Social Security. The ALJ in this case issued a 22-page decision fairly considering the record and relevant here, thoroughly considering Dr. Runkey's consultative examination. Notably, Mr. Jones does not object to the ALJ's decision except with regard to this one small point, which is that he believes the ALJ should have evaluated for persuasiveness one part of Dr. Runkey's report. And that part states as follows. Progressive pain has been occurring due to associated weight-bearing difficulties and joint strain with limitations of grocery store job to about 20 hours per week maximum. And just going forward, I'm going to call that the 20-hour statement. The 20-hour statement is not a medical opinion that needs to be evaluated for persuasiveness. The governing regulations provide that a medical opinion must, number one, state what a person could do in the workplace, and number two, provide what they could do in the workplace in terms of specific physical, mental, sensory, or environmental limitations. And Dr. Runkey's 20-hour statement does not speak to any of that. At best, it's a statement on the issue of disability, which is reserved for the commissioner under the regulations.
Can I pause you on that?
Sure.
Here's what I find hard about it. I think Mr. Sellers makes a fair point that you can read it as a statement as to on those two prongs that you just articulated. And it basically becomes, how do you want to state it linguistically? So here's what I mean by that. You could read it to say, he's able to do that which is physically required to work in a grocery store for up to 20 hours a week. So whatever he's doing in the grocery store, whatever that entails, he can do that up to 20 hours. That sounds like a description of what he's capable of doing. On the other hand, you could flip it around and say he cannot work more than 20 hours at the grocery store. Then it's stated as a limitation. It seems to me it's amenable to both constructions.
Under either one of those constructions, it would not be deemed a medical opinion under the regulations because there isn't any specific limitations. So for instance, if I were to take your example and say, Mr. Jones could stand for 4 hours a day, or Mr. Jones could lift 10 pounds, or Mr. Jones could only occasionally handle. Those are the specific functional limitations that the medical regulations contemplate in defining what a medical opinion is. The regulations were amended in 2017 to clarify the distinction between objective evidence and opinion evidence on the one hand, and statements that the ALJ and the agency determine in disability cases on the other hand. So under the question that you provided to Mr. Sellers earlier, is there a difference between saying somebody could work part-time or saying somebody could work 0 hours? The answer to that question is no, because the regulations specifically set out that a statement that a person can or cannot perform regular and continuing work, that's a quote, regular and continuing work, is reserved for the commissioner.
Okay, so I want to make sure I get what you're saying then. So what if Dr. Runke had said he can work up to 20 hours in the grocery store? I don't remember. Well, I don't know what his job was in the grocery store. What was his job?
He was a cashier.
Okay, and he can stand at the cash register or the scanner. He can help people with credit card payments. He can take cash. He can dispense change. So if the grocery store job was just described in terms of what its physical requirements are, would it then be a medical opinion? Because it seems odd to me that the doctor is going to say, "I'm a physician. I'm not
Yes.
a
Well,
social
that's
security
exactly-
person. I'm just telling you he can work at the grocery store for 20 hours a week." And you're saying the doctor had to type in here what is physically required of the job he used to perform?
Well, that's exactly why the regulations were amended, because a doctor has expertise in certain types of physical limitations, but the ALJ has expertise in whether somebody can work part-time at a grocery store, whether someone could work full-time, what their residual functional capacity is.
But if you say, all it says here is current grocery store job, can you say, well, we know what it is, it's a cashier, so
Right.
it doesn't take a whole bunch of imagination to see what that physically requires of Mr. Jones?
Well, that brings up another salient point, which is Dr. Runke doesn't really explain in his opinion what the grocery store job is in terms of physical limitations. So there really isn't a whole lot that an ALJ can do with something like that. It isn't what the ALJ
Even though
is.
the rest of the record kind of solves that mystery, we know what he does at the grocery store.
Yeah, but the ALJ considered evidence in detail with regard to what Mr. Jones does at the grocery store. Considered his statements, considered the medical evidence as a whole, and might I say also considered Dr. Runke's examination in detail, really considered almost every examination finding. And to be honest, when you look at the consultative examination finding and you're reading that 20-hour statement, it's possible that that statement is even just a recitation of what Mr. Jones told Dr. Runke at the beginning of his examination. Because if you look at the beginning of the CE report, Mr. Jones says to Dr. Runke, I work at the grocery store, but I can only work part-time due to my joint pain. So it's really like not clear at all, what that statement is supposed to mean. But under either scenario, it isn't something that the ALJ needed to articulate in her decision. And that's especially so given, how clearly and thoroughly the ALJ considered all of the other, actual opinion evidence that was in the record. And nothing that Mr. Jones stated in his briefing or in his statements here today changed that fact. And I just wanted to point out, to reiterate the fact that the ALJ, despite what Mr. Sellers said here today, the ALJ far from ignored Dr. Runke's report. The ALJ considered it in detail. And I just want to quickly note that Chenery argument that was raised at the end. That argument really doesn't really make any sense here, because we're talking about a regulation that it states unequivocally that ALJs need not provide any analysis on a statement reserved for the commissioner. So the ALJ isn't going to say anything about that in her decision because she's following the regulation. So the Chenery Doctrine doesn't apply here.
Because you view the 20-hour statement as bearing upon the ultimate decision for the commissioner, disability. Is that right? Why is it not? I think your argument is that if it's considered as in a medical opinion, right, and you're saying, well, it's not, right? You're clear on that. Your top line argument is it's not. But if it's a medical opinion, it's not one that the ALJ has to consider because it's offering an opinion essentially about whether he's disabled or not.
That's correct. And it's something that the ALJ would not need to articulate under the regs. So it's hard to contemplate how Chenery even comes into play if the Chenery Doctrine is that you could only look at what the ALJ states in her decision, because this is something that the regulations expressly state the ALJ need not state in her decision. And in any event, the Chenery Doctrine doesn't apply here because, we're not providing any new rationale. We're just, defending against the arguments that are being used to attack this really thorough, detailed decision that's only being challenged really on one small, tiny point. And if the court has no further questions, we'd request that you affirm the decision.
Okay, very well. Thanks.
Thank you.
Thank you, Ms. Schwartz. Mr. Sellers.
It's hard to understand how this is one small, tiny point in this case. This is SSA's own consultative examiner opining that Mr. Jones cannot work more than 20 hours a week. If his opinion was given weight, even marginally persuasive weight, that is undermining the ALJ's entire analysis because it lends further support to Mr. Jones' subjective allegations. It undermines the non-examining source opinions that the ALJ relied upon, and it belies the ALJ's own consideration of Dr. Runkey's objective findings. So tossing this out as a minute point misses the fact that his opinion undermines the ALJ's entire analysis. It is a crucial part of the record. And if it's just dismissed, that renders Mr. Jones' ability to have a full and fair hearing null and void. And the government effectively concedes, as this court pointed out, that there is some interpretive flux to Mr. Runkey's opinion. It could be read this way, it could be read that way, it could be read this way. That doesn't negate the necessity to analyze that clinical impression. It underscores the need for the ALJ to make the factual finding in the first place. Whether the ALJ believed it was an opinion, whether the ALJ believed it was a statement on an issue reserved to the commissioner, or whether the ALJ just thought it was a statement about the severity of Mr. Jones's subjective allegations and therefore other medical evidence. That's why Chenery applies here, because it is the ALJ who was required to make that factual finding in the first place, and she didn't. She didn't even acknowledge the paragraph that we're discussing about, except for one final sentence of it. The commissioner cannot now come in and say it doesn't matter because we are making the factual determination in court for the first time. That is violative of the Chenery Doctrine. While the regulations provide that the ALJ need not provide any analysis of statements on issues reserved to the commissioner, that does not mean that the ALJ does not need to make the factual finding that it was a statement on an issue reserved to the commissioner. And the ALJ didn't do that here. And the government's broad interpretation of the term regular or continuing work, as we've discussed in our brief at length, is unworkable in practice. And for all the reasons we've discussed today, we respectfully request the ALJ reverse and remand the ALJ's decision. Thank you.
Okay, Mr. Sellers, thanks to you. Ms. Schwartz, thanks to you. We'll take the appeal under advisement. That concludes today's arguments, and the court will be in recess.